class. Welcome to Unit 6 already, well over the halfway mark. And the good news is pretty much from here on in, we are doing criminal procedure, which is some interesting stuff. So a lot of constitutional law um, issues, double jeopardy, Miranda warnings, all that good stuff. So I think you'll really like it, and really kind of getting into the next week a little bit more of the Sixth Amendment, right to counsel. We'll be getting into uh, the right against unreasonable search and seizure, the Fourth Amendment in a lot of detail. That will be the Unit 8 assignment, which is going to be a fun one. And just one second here, can't find the chat. There it is. Okay. Um, just want to make sure everyone's can hear me. Good evening, everyone. So as I was saying, so Unit 8, we'll talk about the Unit 6 assignment, but just to kind of look ahead, the Unit 8 assignment is going to be on a little chart on the different, uh, actually the different exceptions to the Fourth Amendment warrant rules. So that will be an interesting one. And then the Unit 9 assignment, we go back to this Alex scenario, and you come up with some opening statements in the case, or actually closing statements, and a list of witnesses you want to testify. So some good assignments ahead, not too bad, and we'll talk about the Unit 6 one. So basically, we're into constitutional defenses this week. And we'll focus mostly on double jeopardy under the Fifth Amendment, as well as Miranda warnings. And the discussion question this week is really good on immunity and whether a person has to testify if they are granted immunity. Um, so the reading this week is chapter 9, constitutional defenses. Let me just make sure that is correct. Yeah. Um, and then the Unit 6 discussion question, which we'll talk about a little bit tonight, immunity for witnesses. The Unit 6 assignment, we're back to Alex on his spree. We're coming up, though, now you're putting on your defense counsel hat, and you're coming up with defenses for Alex. So you're hopping on the other side of the bar, uh, of the bench, I should say. And so um, and again, we will talk about, we probably won't get to the First Amendment tonight, but I'm hoping to cover the Fifth and mostly the Fifth Amendment. But we still have another week next week on constitutional defenses. So what we don't get to tonight, we can get to next week. Hi, Andrea. So let's hop ahead here. So this is the Unit 6 assignment. Again, we're looking at potential defenses. So it's basically the same format of the Unit 4 assignment, pretty much the same setup. You're still doing IRAC method, but instead of identifying crimes and applying the wording of the statutes to the actual facts to determine if you've met the elements, you're going to be doing that with defenses, which are mapped out by statute as well. And remember, when you're doing that, I reckon I have to say, I was impressed with those papers. Remember, you really, you want to really hit that analysis, that IRAC method perfectly. You want to, the reason you're quoting the key wording of the statute is so that then in that analysis part, you can show exactly how the elements or the wording of that statute apply to the facts, so that you can show how each one of those elements can be met. So be sure to do that with the defenses too. So you can use either the statutes that map out the defenses, and they're in a little bit of a different spot, but I have a link for you to them. And so you can either choose one of those. You only need 2 defenses, so it's not the 3 that you had in Unit 4. And one could be a constitutional law defense. So, for example, you could point to the issue of the fact that Alex was not read his Miranda warnings. So that could be one defense, and then Colorado law, your other defense. So this should be at least 2 pages. Again, I would use that same setup of an introduction and then doing IRAC for each defense. So just as you did IRAC for each crime one at a time, because that's how IRAC works beautifully. Because if you take one crime, you state you identify that crime, you bring in the rule or the statute, you apply that statute to the facts, and then you conclude. Then you're done. Then you go on to the next crime. So that's what you want to do with defenses too, because that's where you really see that analysis. If you kind of if you lump them all together, like these are the three crimes, these are all the statutes, it's very difficult to see the analysis that way. So here are the statutes, and in fact, let me put that right here. So that should bring you right to those statutes. There's only like 4 options. And so I would point to, if it were me being the defense attorney, and again, you want to consider, which are his strongest defenses. He's probably best off looking for, I mean, there's no doubt he went on this crime spree and he's looking pretty guilty, but he could try to, defend or mitigate these crimes using either his impaired mental condition, which is the phrase used in 803, or intoxication. Now, voluntary intoxication, is not an outright defense, but it could be used to mitigate the crime. For example, first-degree murder requires an intent to kill. But if the defense attorney shows that he was too intoxicated, and intoxication can mean drugs as well, not just alcohol. So if you can show that he was just gone because of all the drugs and alcohol that he consumed, then perhaps you could show that he actually didn't have intent to kill. So that's one argument. Again, if you choose the constitutional defense of the failure to read Alex his Miranda warnings, our book has a really good section, but it's actually not in the reading for this week. It's for the reading ahead. I think it's next week. So remember to check out chapter 14, and it's a good hunk of pages. It's pages 407 to 419, where it talks all about the Miranda rights. And we're going to talk about them tonight as well to help with that. In fact, I'll try to go quickly through double jeopardy so we have more time for Miranda warnings. A little more on this though. So again, some tips on how to set it up. So introductory paragraph, kind of summing up, and as best you can in your own words, so that you're not just taking the wording from the assignment, because you want to, kind of sift through and pick out those key facts. Discuss defense number 1, identify it. And you can either just identify that defense or put it into a question. Would the defense of intoxication, apply to Alex in this case, something like that. The rule is the relevant Colorado statute that sets forth the elements of the crime, or in this case, the elements of the defense. And then, and it is better to use that actual wording of the statute, that, not the whole thing, but certain parts, so that you're using that key wording and then you're showing how that key wording applies to the facts. So then in the application, how the elements in the statute of law apply to the facts, and again, use the wording to show that connection. And then your conclusion, always likely to be acquitted of, or the charges may be, his punishment may be mitigated because of blah, blah, blah. And then you would go on to defense number 2, and then kind of an overall conclusion. So just remember, one defense at a time. It doesn't have the rhyme that one crime at a time has, but remember not to lump together, do one defense at a time. So again, it's just like the Unit 4 assignment, but instead of identifying crimes, we're identifying defenses. But you do want to, as that says on the bottom, identify the crime. You do want to connect which, when as you're discussing the defense, you want to explain, point out for which crime is this defense going to work. So, for example, if you talk about intoxication, you would want to point to this is going to work for, first degree murder because we could show there is no intent to kill. So you want to connect it to the particular crime he's being charged with. So it might help to kind of go back to your Unit 4 assignment and see what you charged him with. I mean, you don't have to keep an exact alignment, but just to kind of remember what charges he is facing, so which defenses are going to work best. Um, exactly this. I think that's the best way to do it, is just kind of a quick overview of the facts, not everything from the assignment, but just kind of a quick overview to hit those key facts, and then go into the first defense and do IRAC, and then hit defense 2, hit IRAC, and then kind of an overall conclusion. So sure, and it's kind of, the two IRACs, you can think of them as sandwiched between the introduction and the conclusion at the end. Cool. All right. Um, so here are a couple of statutes on defenses. Now, I was going to talk about the impaired mental condition simply because, and we kind of got into that on the discussion question last week, that the insanity, talking about novel defenses and regular defenses, but there's a lot of studies that have been done showing that the insanity defense is actually, it's often, people often say, oh, it's overused, it's always made up. But in reality, it is so difficult to win on an insanity defense because you have to have, a psychiatric, an expert who is going to say that the person is insane. It's not an easy road. So a, a very, very low percentage of defenses are based on insanity. And when they are brought, the success rate is very low. I think it was about 20% or so. So it's not a highly successful defense, because then I think part of it is because of the bad rap it gets. Jurors often don't believe it. So one route might be to avoid that major problem is the impaired mental condition. So here, it's not it's not legal insanity, but you could say that he did have an impaired mental condition, especially in this case where he was off his prescribed medications for over 2 weeks, and he was drinking on top of it. Now you would have to differentiate between showing that that was due to his impaired mental condition and not totally based on the drug. So it's going to be a tough one. Yeah, and did I see a hand up? Yep. Do you want to speak to us?
Yes, I did. So when I was kind of working a little ahead, and so I was reading the case and kind of going to get my defense. And I saw one that was diminished, or the diminished can't say the word,
Capacity?
capacity.
Yeah.
Um, and then I wanted to do the insanity defense, but then I mean, it kind of goes, I don't know. For me, I'm really having a hard time separating the two
They
because they kind of go hand in hand to me. I mean,
They do. They do. Yeah, they're very similar. And I think really the only difference is the insanity defense is just a harder thing to prove because it in Colorado follows that monoton, which you have to show there's a underlying mental disease.
that's what I was about to say. So I was gonna ask you if I did that. We just don't know the background and history of um this scenario. So it'll be hard to use that
It,
defense not knowing his background. Why was he on the meds? You know what I'm saying? Kind of
right.
did it with any trauma. So would it just not be smart to use the insanity defense?
That's true. I think you could, but you're exactly, yeah, we only know that he must have had something going on because he's been prescribed these meds. But I think that because just kind of the overall difficulty of proving insanity and the fact that he's also on drugs and alcohol, which could kind of
Right.
interfere with things. I think the impaired mental condition might be a better way, and that way, and it's not going to get him off from the charges, but at least it will bring, what's the term I'm thinking? Mitigate his punishment. So, and it could also lead to that he will get mental health treatment, for example. So there is Colorado does have a guilty but mentally ill category too. So you could certainly talk about that too. The kind of the tricky thing about Colorado is that the statute, um, if you look at the statute on insanity, it applies to cases that were committed prior to 1995. So it actually is under this different approach, but this explains it well, this co-defense law. Um, so that's kind of a tricky thing too, but I wouldn't rule it out. I think it would be interesting to talk about it. But it is, it is more difficult because unlike the impaired mental condition, there has to be a disease of the mind. There has to be a psychiatric exam. So it's a harder climb. Um, but you could even one way to do it is to if you don't have to do one as a constitutional defense, so you could do impaired mental condition and insanity defense to just kind of compare the two. Since you've already started in on that, I think that might be a interesting
Okay.
approach too. Yeah. Um, so yeah, good question. And I think that's, as you can see there's the definition of um, you know, mental disease or defect. So it's really just kind of maybe you could think of it as a little bit lower level of insanity with impaired mental condition. So it's a little easier to prove, and it may work more than insanity to either bring down the charges or bring down the punishment. But this is if you do the insanity defense, be sure to check that link out because and I'll put it. I don't think it works from this slide, so I will put it here. Um, it's kind of hard to find much. I found a couple of articles that were talking about the insanity defense, but I'm not sure why they changed the statute so that it only applies to cases before 1995. But so now it's more handled by this link will bring you to actual more jury instructions. So I guess that's the approach they're taking now. Um, and there is a good article that I think that will be helpful. That one down there when mental health becomes an issue. So I think between those two things, that will help a lot with that defense. And I'll put that in there too. I think that will work. Um, but I will, of course, send the PowerPoint after class, so you'll have all these links working. And so let's go to the next slide. On the intoxication, so intoxication one is tricky because it starts off by saying intoxication of the accused is not a defense to a criminal charge. But then it says except as provided in subsection 3 of this section. But in any prosecution for an offense, evidence of intoxication of the defendant may be offered by the defendant when it is relevant to negative, which is a weird word to use there. I would have thought it would be negate the existence, but they use negative of specific intent. So again, you have a crime such as murder, intent to kill. If one can show that Alex was too intoxicated to form that intent, then that may be a very strong defense and a way to at least bring it down to, say, second-degree murder. And so and the other part of this is intoxication. Part of it would be differentiating intoxication from the mental health issues that he has too, because as it says down here in let's see what section. Yeah, so section 4, intoxication is used in this section means a disturbance of mental and physical capacities resulting from the introduction of any substance. And then goes on to say self-induced intoxication, which of course he engaged in, um, means intoxication caused by substances which the defendant knows or ought to know have the tendency to cause intoxication, which he knowingly introduced. It goes on and on. Um, so, so that is one possible defense. Again, it's not going to get him off all of these charges, but it is a way to use it to uh, negate that required intent. Um, so there's a couple of articles there that should help. Interestingly, speaking of the insanity defense, there's actually a case going on right now, and I just put it into the email I'll send after class, but it's that one. Remember, it was 2021, the horrible grocery store shooting. 10 people were killed in Boulder, Colorado. The defendant is pleading insanity. So that would be kind of an interesting case to look at. So I sent one article on that that talks about it, and it actually is interesting timing because this was on the September 4th, which was yesterday. He was in court arguing the insanity defense. So this might be kind of a good way to see how it's playing out in a real life case. Um, So that is, and I like this quote, a little Latin, uh, qui peccet ebrius on luat sobrius, which is Latin for he who offends while drunk suffers punishment when sober. So a very deep Latin quote there. And feel free to use that in your, well, no, you wouldn't want to use that in your paper because you're on the defense side. Maybe in the Unit 9 assignment. um, so a little overview, a little checklist there. So did you identify the two defenses? Did you bring in the Colorado statute? Is it BIRAC or IRAC? And did you include in-text citations? You need those in-text citations, same format. Remember all you need really is, let me go back up here. As long as you have, whoops, I think it's one more. Yeah, as long as you have that format, well, not that format, I didn't include. There it is. So right there in the middle, Colorado Revi, that's Blue Book format. And so, oh, I can't copy that for some reason, but that's really all you need. And you really can just use that in the reference too. You don't have to put, the whole link and all of that because the beauty of Blue Book is it tells you exactly where you can find that statute on, on Westlaw, on Lexis, wherever you may be, or just on Google. So you don't have to do any more than that for your citations and references. Oh, I know. Wasn't that I know, Andrew, I was watching the news about that. That was awful. I just kind of saw the kids who were, who witnessed the whole thing, but I haven't heard any details on the shooter. Um, because he is still alive, right? They did catch him, um, so he will be tried. I think
Yeah, they
in
called him. He's
okay,
14. We talking about the one that happened in Georgia.
yes,
Yeah,
yeah.
he's 14, and he'll be
Oh,
tried as an adult. I was gonna actually ask you about that, but I kind of looked it up, and it is a state. They can't charge him as an adult, in that crime because state law is 14, but it's the act of the crime that he committed. So they are going for trying him as an adult.
oh, wow. Oh, man. Wow. 14 years old. Um, that's sad. Um,
I
yeah,
don't
just
think. Can I answer that question? Someone just asked, did he have ADHD? Um, can I answer that?
sure. Yeah.
There's that's gonna be a hard defense to say he had a mental condition as ADHD that will make him
Yeah.
go and kill people. Like it's a lot of people that have ADHD that
Yeah.
you can't keep using that as a defense, but when they have access to rifles and guns, they know how to
Mm,
do it, they know how to use it, they know what it's meant for. So
Right.
I like to throw that out there. Like
Yeah.
it is a huge stretch. It
Yeah.
is a very huge stretch, but people want to use mental illness. Sometimes it's just pure evil. And I
Yeah.
think that at the end of the day, if you can learn how to shoot a gun and aim it at someone and
Mhm.
your intent is to hurt or harm, then that means you got enough sense to
Right.
know right from wrong.
Yeah.
Um, but yeah, I know people are gonna use that defense, but I'm
Yeah.
sorry. Yeah, you have to be crazy to do what you did at 14, but I also believe there's some behavior that might have been taught or some behavior that he saw or something.
Right.
Nobody just gets up in the morning and say, "Oh, let me go kill somebody."
Right. And like Melissa said, I mean, maybe it's, in some of these cases, the parents have a whole, stockyard of guns. It's like it's crazy.
Right. Like
Yeah.
they give them access to this stuff and then they don't then they leave them alone and then they expect them to know how to cope with their feelings, but they have
Right.
weapons that can harm people. So yeah.
Right. Yeah. And I wonder if he was, I wonder if he was that whole thing of being bullied, and not that that's any excuse either, but it seems like that's oftentimes the situation. Um, but sad. Yeah, I think we'll hear a lot more. Right. And as Sherry said that, if they just sort of relevant to the crime. Right, it just doesn't seem, but it's interesting that has already come to light. So you do wonder if he's working on, or the defense counsel is already coming up with ideas. But yeah, we'll have to watch that over the next week or so. But thank you, Faith, for that. Um, so I think we are done with the Unit 6 assignment. Any questions on that before we hop ahead? All right. When we talk about constitutional defenses at trial and also at sentencing, we've got a whole list. We've got the Fifth Amendment, double jeopardy, and that, of course, prohibits the government from putting a person in jeopardy of a conviction or punishment twice for the same offense. So the wording of that, no person shall be subject for the same offense to be twice put in jeopardy of life or limb. We've got the Fifth and the 14th Amendment due process clause. So the Fifth applies to the federal government, the 14th to the state. We've got the Sixth Amendment, the right to fair trial, right to counsel, a lot of rights packed into the Sixth Amendment and into the Fifth Amendment. And then finally, the Eighth Amendment prohibition against cruel and unusual punishment. So these are all the things we will tackle here. Um, so let's start with the Fifth Amendment. And of course, when we say the double jeopardy clause, you can't help but think of the the Double Jeopardy movie with that was one good movie with Ashley Judd uh and who was the probation officer in that case? I just love the way
Tommy Lee
Tommy Lee
Jones.
Jones, that was it. Thank you. The way she kept getting away from him, that was awesome. And the interest, I'll send an email in my email after class. I'll send you a little link that it talks about how she actually couldn't have used it. Well, it kind of turns. Well, I don't want to give it away. If you haven't seen Double Jeopardy, you have to see it. It's awesome. But the article speaks to why she actually wouldn't be able to use that defense. So it's kind of interesting. But yeah, if you haven't seen it, Double Jeopardy, probably Netflix, at least Amazon. But it is a good movie, a little older. Um, so the Double Jeopardy clause safeguards individuals from being tried over and over again. Because if you think of it, here's the government, all this money and resources, a whole team of police and prosecutors. If they want to get someone, they can. They can just kind of come up with all kinds of things to go after someone. So the double jeopardy clause steps in to protect people against that. And so the way they do it, there's two restraints. The government may not retry a defendant for the same offense following the defendant's acquittal or conviction. So once the trial is done, it's done. They can't have a second shot at it. And the government may not impose multiple punishments on a defendant for the same offense. So let's take a look at how, whoops, at the requirements of this to bar re-prosecution or another trial from coming after a defendant. So first, it has to be shown that jeopardy attached in that first trial. The subsequent prosecution involves the same offense, and both prosecutions are brought by the same government entity. So those three requirements have to be met. So the first one, did jeopardy attach? So for this one, jeopardy attaches if it's a jury trial, then it attaches when the jury is impaneled and sworn. So in other words, at that very point, once that happens, once the jurors are sworn in, then the prosecution has to carry out the trial then and there. They can't just quit and say, okay, we're going to wait and then bring charges later on. That's their chance right there to follow through and get a conviction. If they don't, that's it. If it's a bench trial, so just before a judge, no jury, when the first witness is sworn for testimony, that's when jeopardy attaches. So the idea of this is that, once trial begins, jeopardy attaches, defendant has the right to have it all resolved. All the charges are resolved, and this is the government's one and only shot at it. Because when you think of it, if this wasn't the case, the government could kind of, say, hey, let's, give it a try, no pressure, we can always try again. And then they kind of get a lot of information the first trial, and then they come back stronger in the second trial. And this person could just be sort of pestered for life with trial after trial being, charge after charge being brought against them. Whoops. Sure I didn't miss something there. Okay. So one interesting thing, that there are three exceptions that do allow retrial after jeopardy attaches. So if the defendant requests a mistrial, then that is an exception and a retrial can take place. So unless it's something the prosecutor did, so prejudicial error by the prosecutor. When the first trial is terminated early due to what's called manifest necessity, so a jury deadlock, for example, hung jury, war, or illness of the accused or judge, that can be grounds for, ending the first trial and then allowing retrial. And then when the appeals court reverses the defendant's conviction because of error by the trial judge, defendant can then be retried. The case is often remanded back for a retrial. Oh, good, Melissa. Kind of an interesting thing is, back in the days when COVID was so rampant, in 2020, remember trials were either being put on, they were on Zoom, or they would just, there would be attempts to have the trial, but then it would have to be stopped because the juror would get sick or the judge would get sick. So in this one case in New Jersey, a trial judge declared a mistrial in the defendant's case after all jury trials were suspended due to COVID, and they hadn't resumed for 7 months. So the defense objected and said, no, we don't want this trial we want to resolve it all. But the appellate, so it was brought to an appellate panel. The appellate panel held the judge was within his authority to declare a mistrial because of the legitimate needs of the party's attorneys. And the judge probably did it really to help the defendant because, here, if the trial starts and then 7 months go by, not really fair to the defendant, especially if they're in jail waiting it out. So that's what the judge did. So double jeopardy would not be violated if then there was a retrial, because the termination was required by a sufficient legal reason. So this would be so COVID really was an example of manifest necessity. And kind of before that, there really hadn't been any instances of, say, illness being enough to be manifest necessity. And so one of the interesting things too about this is that the appellate panel pointed to the judges, their sincere motivation to help the defendant, but the court pointed to this fact that unfortunately for the defendants, the conviction rate is much higher for retrials than it is for initial trials. And it's due to the fact that prosecution already has this preview of what the defense is going to bring in as a defense strategy from the first trial. So that's really kind of an interesting thing to keep in mind. So even when a defendant is found guilty, but then it's found at the appeals level that the judge made a mistake and that the trial there has to be a retrial, the conviction rate is higher for that defendant, because the defendant the prosecutor already has a preview of the strategy. So that's a bit unfair, too. Oh my gosh, yes, Johanna, I love that is one of my favorite videos is the lawyer saying, I am not a cat. And the funniest thing about that too was the other, you can clearly see this cat face on Zoom, and the and the other lawyer's just sitting there like so serious. It's like, how could you be that serious seeing the cat face? I would have been dying laughing. Yeah, that was awesome. Yeah, a good road to fame. Um, yeah, I guess he just didn't think it was funny. Um, so the second question, I should say, does the subsequent prosecution involve the same offense? So the double jeopardy clause prohibits the subsequent prosecution of the defendant only if the charges are for the same offense as in the previous prosecution. So this gets tricky. So there's two tests for determining this. So one is the Blockberger test, and this is also called the same elements test. This is the one the federal government uses. Most states use this. And then there's the same transaction test that is more fair to the defendant, but not as many states use that. But under the Blockberger test, two or more criminal charges are not the same offense if each charge requires proof of an additional criminal element. So, either another form of intent, additional act, carrying a weapon. The same transaction test is that the prosecutor has to join all the criminal charges deriving from the same underlying criminal conduct by the defendant, for the prosecution in one single trial and get it all over with at once. And that's it. That's the end. That's much stronger safeguard for the defendant to get it all done and it over with. But unfortunately, again, most states use the Blockberger test. Just as a quick example, so under the Blockberger test, say robbery and armed robbery are actually are not the same crime because under the same offense, the Blockberger test, because one has an element that the other does not. So for armed robbery, there has to be proof that the person was armed, so with a deadly or dangerous weapon. In example 2 here, say we have Roberetta who enters. That was a weird noise. I think, you okay, little buddy? She just made a weird noise. So Roberetta enters a federally insured bank, pulls a gun out of her jacket and points it at the teller, yelling at the teller to fill the bag with cash, and speeds away. So here we have 5 offenses. We have armed robbery, carrying a concealed weapon, making a terroristic threat, reckless endangerment of the people in the bank, and speeding. So if it was the same transaction test, which is more favorable to the defendant, the prosecutor would have to put all these 5 crimes together and charge it at once. But under the same offense, because each one of these crimes has a separate element than the others, they could all be brought at different times. So you can see the difference there, that how much more protective the same transactions test is. And the next question, let me make sure. Okay. The next question is the same governmental entity prosecuting? So the double jeopardy clause, it prohibits multiple prosecutions, multiple punishments, but only if they're by the same governmental entity. So a person can be prosecuted convicted in federal court for a crime, so say bank robbery, usually handled as a federal crime, and then be prosecuted and convicted for the same criminal conduct in state court. So oftentimes, armed robbery is dealt with in the federal courts, and that's the end of it. But technically, the armed robber has committed a crime against both the federal government and the state. So the state has every right to go after the robber as well, because the robber has violated the states of both the federal and state governments. So it is possible to face charges from both. And so there's separate sovereign entities, the state and the federal government. If the criminal commits crimes in several states, could be prosecuted by all those states. Remember I think this was in the 80s. Remember the Beltway sniper? It was that case where it was this young man, it was Malveaux, and I think the older man was, I think it was Mohammed and Malveaux, and he was an older man, and he had this younger kid who he was kind of teaching in a bad way how to shoot people. Basically, they would go around and park the car, and the kid would do sniper shots out the back, and they were shooting and killing people all over the Beltway area around Washington, D.C., Maryland, and people were just, yes, it was called the D.C. sniper, exactly. Oh, really, Melissa? Yeah, that was a shocking time. Um, and people were just petrified. One woman was a federal officer, and she was shot while putting gas in her car. I mean, it was just ridiculous. Um, so that case, all of those states could have brought charges. But oftentimes they kind of get together and they call it multi-jurisdictional cases. So the different prosecutors from all the states will get together and say, okay, which state should go first, or which state should handle usually they decide that by which state has the most serious punishment. So they were punished I should say charged in Virginia, because Virginia had the death penalty. And remember, the older man did get the death penalty. The younger kid did not, mostly because he kind of turned state's evidence against the older guy. But that was one case. And you see these cases where people, just go from one state to another. Um, and that's okay. It's okay for each state to step up and prosecute someone, because they're all sovereign governmental entities. And so it's called the dual sovereignty doctrine. And it kind of originally started where both the federal government and the state can bring charges, but it also applies to several states, or to several states and the federal government. So a couple of examples of the dual sovereignty doctrine. So again, it's not a violation of double jeopardy if there's two separate jurisdictions prosecuting the defendant for the same criminal act. So there's one case, Heath versus Alabama. It's a 1985 case. This is a Supreme Court case. The defendant had hired two men to kill his wife. The men kidnapped the wife in her home in Alabama and killed her and left her body alongside the road in Georgia. So the Supreme Court of the United States held that under the dual sovereignty doctrine, the defendant could be prosecuted for murder in state courts in both Alabama and Georgia, because the plot was planned out in Alabama. That's where she was kidnapped from. It all started there, and then she was killed and her body was left in Georgia. So both states had an interest to prosecute this guy, because he violated the laws of both states. And that's not a problem with so each one could charge murder, the same crime, but it's not double jeopardy. There's another case, Bartkus versus Illinois, and this is an earlier case. SCOTUS held that the criminal defendant could be prosecuted by both the state and the feds for the crime of bank robbery. So he was charged by the feds for bank robbery. Then the state came in and he said, "Oh no, this is double jeopardy." The court said, "Nope, it's not. It's two sovereign entities going after you, and that's okay." Um, one example too, that's I think a really interesting one that shows why it's good to have separate sovereigns is separate sovereigns is the Rodney King case. So remember, the initial trial against the LAPD officers, remember the state of California charged the defendant police officers under a California statute. It prohibited the use of unnecessary force by a public officer. Well, and I'm assuming everyone knows the case of Rodney King, but it was quite a while ago. So just as a summary, he was stopped by California police and just brutally beaten for no, not just cause at all. It was just a horrible thing. And this one person who lived nearby caught it all on camera. If not for that camera, the police may have very well gotten away with it. But the police, after all this and after all the evidence they had, the officers were acquitted in the state charge. So the federal government really seeing the injustice here, because remember sometimes the state, the state, the judge, the way that the case was handled, the judge could have been biased in favor of the officers. So the federal government is often, more of a neutral forum. So they stepped in, charged the officers in federal court with violating a federal statute that pretty much does the same thing. It prohibits law enforcement officials from, but it was a little stronger, from willfully misusing their positions to unlawfully deprive individuals of constitutional rights, such as the right to be free from unwarranted assaults, illegal arrests and searches, and theft of property. So that trial ended up, they were convicted in that trial. So while they were able to be acquitted in the state, they got justice came along in the federal court. And so it shows really the advantage of having the federal government out there in case some a bad actor gets away with it in state court. And so basically it's a federal civil rights statute, and it is a powerful way to prosecute state actors, usually police officers, but there are a lot of state actors. It could be, for example, a child protection worker who in some way violates an individual's constitutional rights, but who, escape conviction, as in the Rodney King case. So because, again, states sometimes are a little bit too favorable to their own people, especially law enforcement. Another case dealing with the dual sovereignty doctrine is Gamble versus the United States, a much more recent case, 2019. But this is a case where Gamble pled guilty to violating Alabama's felon in possession of a firearm statute. So he didn't have a trial, he just pled guilty. The federal prosecutors then, and so he got his sentence for that. Federal prosecutors then came in and indicted him for basically the same crime, but under federal law. Gamble then argued that his federal indictment was for the same offense, kind of like, what's going on here? I just pled guilty to the state. Now the feds are saying I have to face trial for the same exact offense. And it really is the same exact offense, felon in possession of a firearm. But so he's saying this is double jeopardy. But the court said, nope, it's not double jeopardy. It's dual sovereignty doctrine, and that's the key exception. That even if he was just faced the music in state court for the same thing, as long as it's the federal government coming in, even if it's a very similarly worded crime, almost the same thing, it's okay because it's dual sovereignty. So the idea is that the offense, is defined by that particular sovereign, by the state or the federal government. And so even though they might look alike, it's two separate crimes. And so each state or federal government has the right to go after the defendant. So that's the dual sovereignty. Kind of an interesting aspect of this too is that in 2016, there was a case, Puerto Rico versus Sanchez Vale. So in this case, again, dual sovereignty doctrine, the court said that the the same criminal conduct can be punished by two sovereign governments without violating the Fifth Amendment. But the problem was that the court said that the federal government, state governments are separate sovereigns, but SCOTUS found that Puerto Rico did not have separate sovereign status. And this was highly criticized because many say, Puerto Rico should be considered independent, have its own, it's a US territory. But what the court said that is that it doesn't have a separate sovereign status because its status can be traced back to Congress, which is the same source that gave power to the federal government. So they're saying because you can trace both the federal government and Puerto Rico back to Congress, then Puerto Rico and the federal government are not separate sovereigns. So in this case, the SCOTUS deemed Puerto Rico and the United States, I mean the federal government, a single sovereign for purposes of double jeopardy. So both governments could not prosecute the defendant for the same offense. So it went in favor of the defendant in this case because he had already pled guilty to possession of an illegal firearm under federal law. So he's already facing punishment for that. And then Puerto Rico indicted him on charges of violating the Commonwealth of Puerto Rico's gun possession laws. But SCOTUS said, nope, can't do it because you're not a separate sovereign. I think, that's and Melissa, on that question, it hasn't been actually litigated, but I would say from this precedent that any territory would be the same. So Guam, Virgin Islands would probably be in the same situation because they would all be, any US territory would be traced back to Congress as kind of that original source. So good question. So on the punishment, so the double jeopardy clause prohibits multiple punishments for the same offense as well. So then we have to decide, well, what's a punishment? So it's only multiple penalties that are prohibited. And this gets really tricky. What's a punishment? What is a burden to kind of, help society for the benefit of society? For example, Megan's laws that require convicted sex offenders to register with the police, or if they move into a neighborhood. There have been many arguments that these are criminal penalties on the defendant, but the other side of that is no, they're not a penalty. It's just kind of an administrative burden that we want to know where people are living. People who are convicted sex offenders are living for the safety of others in the neighborhood. Or forfeiture laws, for example, police stop a car and they find drugs in it, and then they confiscate the car and all the drugs and money in it. Is that a criminal or is it a civil penalty? So the court, to determine that, the court determines or examines what's the government's purpose for imposing it in the first place. So if the purpose is non-punitive, more for society, then it's characterized as civil remedy. And the court it will just be civil punishment, won't be an issue with double jeopardy. So for example, asset forfeiture, so it's okay, there's no double jeopardy if there's a criminal sentence and then if it's followed with asset forfeiture. So again, the guilty property, so police, stop a car, it's got drugs and money in it, that's thought to be guilty property that the police can confiscate. And is saying that furthers non-punitive goals because you're preventing these criminals from profiting from their wrongdoing. They can't use the car to further commit their wrongdoing, for example. But there was a case, Timms versus Indiana in 2018, that was the first case to limit how much police can grab in civil forfeiture, because that's been a kind of an ongoing major problem that police have been, taking. In this case of Timms, the police actually stopped these two guys. They were speeding a little bit. And one of them had a bit of marijuana. He wasn't selling it, but he had some for personal use. And this was when marijuana was illegal. So that gave the police the right to search the car, and it was a Land Rover, a pricey car. So the police searched the car and they found all this. It's just a ton of money in the car, like all these dollar bills. So they're thinking, okay, big drug dealers here. They were actually poker players who would travel from one place to the other and play poker. So they weren't real criminals, but that one happened to be smoking pot in the car, and that kind of led to their downfall. So the court did say, this is too much. This is too much of a forfeiture to steal their, to take away their $42,000 Land Rover and all the money they had in the Rover. So this was the first case that set limits on how much police can take. Also on Megan's Law, so they have been determined to be non-punitive and civil, because the idea is that, protect the community rather than imposing further punishment on convicted sex offenders, for example. So that can get a little tricky, those kinds of issues. And we still have 5 minutes to cover interrogations, but at least we can start on it. So when we get to interrogations here, have to show this picture of the Star Chamber. You've probably all heard of the Star Chamber in England. So this is just this terrifying practice that, I mean, you can see that guy standing there does not look like a friendly dude. So they would just beat the heck out of people to get them to talk. And as we know, that isn't a way to get a legitimate confession. And so the idea is the Fifth Amendment right really kind of came up, and see the stars on the ceiling. This was actually a picture, a painting of the Star Chamber. So it was a place where suspects were brought in. They were basically tortured until they confessed. And so, and this would go on for hours and hours until they confessed. So it was just a terrifying practice that the founders in this country wanted no part of. So that's why the Fifth Amendment contains the right against self-incrimination. So a person cannot be forced to give themselves up, so it provides that no person shall be compelled in any criminal case to be a witness against himself, which is really cool, because what it means is the prosecutor has the whole duty to bring, to show that the defendant did these charges beyond a reasonable doubt, and show every element of the crime beyond a reasonable doubt. And the defendant doesn't have to say anything. They can just sit there and not say a word. It's I think if the term privilege is used. It's really just more of a right against self-incrimination. So a constitutional right not to be compelled. So if, and this is really where Miranda comes into play. So prior to the Fifth Amendment, right against self-incrimination has been around for years, but in the 60s, it kind of came to light in the Miranda case that police had this practice, kind of like the Star Chamber practice, of bringing a suspect that they figured did the crime, bringing them into this small interrogation room under the bright lights and questioning the person for hours, no food or drink until they confessed. And again, that's so even though the Fifth Amendment was there, the defendants didn't know their rights. So that's what Miranda is all about, is that the police have to inform suspects that, you have the right not to, not to incriminate yourself. You have the right to an attorney. So giving them really this list of rights in case they don't know, and a chance to assert those rights. So it's more of a right than a like evidentiary privilege, but it sure is an important right. And oops, I think I skipped a slide. Let me go back one. Oh, okay, there we go. So the right against self-incrimination, it goes to the heart of our accusatorial system, where the government has to prove the charges against the defendant through their own work. They have to do the investigation, independent investigation. They can't just, bring a person in and torture them until they confess. That's just not right. And so the Fifth Amendment protects suspects from being compelled to give testimony only. That's one important thing to remember. So the government can make a person, say if there's a murder suspect and they want to get, DNA under their fingernails, they can do that. They can get that DNA, or they can get a blood sample, or get the person to participate in a lineup. That's not testimonial. That would fall under the Fourth Amendment, the right against unreasonable search and seizure. So it has to be that the police had either a warrant to bring this person in, or they had, probable cause that met the Fourth Amendment requirement. Oh, we are out of time. Well, we did good. We got through double jeopardy. I will remember this slide 30, and we'll pick it up there. I guess there we go. We will start off at finishing up self-incrimination. We'll get into First Amendment defenses next week. So we'll keep it going strong. Oh, you're welcome. Good work tonight. And do let me know if you have any questions about the assignment. But we have a few good weeks of this stuff. I love this criminal procedure stuff. So thanks, everyone. Have a good night. Thanks for your input, Faith. And take care all. You too, Tracy. Have a good night. Good night, Andrea and Johanna and Al. Take care all. I will send this PowerPoint right now.